So there's yet another update in the H3 podcast case. Really interesting. There's now no H3 podcast case, but not because of a dismissal. Let me explain. The case is still labeled Triller Fight Club versus the H3 podcast. And we can see May 10th the complaint is filed, and then we go through a lot of the things that we've already covered. But then May 21st here is the first amended complaint against defendants Ela Klein, Ethan Klein, and Ted Entertainment. Turning to the first amended complaint itself, we can see that there is no more H3 podcast listed for the defendants here. It's Ted Entertainment, where we'll look at this ourselves and see what exactly is going on here. Everything over here seems to be the same, so we probably don't have to cover all of that in great detail. But let's see if we can find out what is new. So here we have a screenshot of a television. Description automatically generated with low confidence. I guess this is some kind of smart something or other. Here we have a screenshot of the H3 podcast number 244 showing that Ethan talked about the fight. And there's a red circle here. I don't know. Maybe we should submit this to Reddit, our useless red circle, because you can't make out what that is. Like I can zoom in and there's nothing to see. There's no further resolution there. I'm not sure what they expected that to show, but it does show that the Jake Paul Ben Askren fight was on the H3 podcast 244, but it doesn't really change my opinion about it being fair use or not. If Ethan commented on it sufficiently, then it's fair use. Doesn't matter that it's the heart of the fight, and I think it will matter that he didn't do it live during the fight. I'm not sure exactly when the fight was. Maybe he did do it live during the fight. I don't know. Those will all be arguments that we'll get to hear shortly, because now H3 has also been served. Let's continue and just skim through this. Defendant Ted is a corporation registered in California. Chief Executive Officer is Ethan Klein. Secretary is Mrs. Klein. Ela owns and operates the YouTube channel. Let's see, the YouTube channel ends in 1KW. Is this the same YouTube channel, 1KW? Yes. Okay, so it's the same YouTube channel. So it just seems like the first amended complaint here is amending the defendant to be the correct corporation. If we look at Rule 15 of the Federal Rules of Civil Procedure, a plaintiff is allowed to amend once as a matter of course within 21 days after serving a pleading, or 21 days after service of a responsive pleading, or 21 days after service of a motion. So as a response to a motion to dismiss, you could file an amended complaint trying to correct the things that were addressed in the opposing party's motion to dismiss, or within 21 days. So if we go back here, they hadn't served the complaint yet, so they get to amend it as a matter of course. They don't have to ask the judge for permission. In another video, we're going to talk about the Rutenberg v. Twitter case, which was dismissed, and then there was a second amended complaint that the plaintiff wanted to file, and that you need permission for. The rule says, in all other cases, a party may amend its pleading only with the opposing party's written consent or the court's leave. The court should freely give leave when justice so requires. But we're not there yet. We're just here on the initial first amended complaint. So that's what they've done, is updated the defendant to be the correct corporation, this TED corporation. They are trying to pierce the corporate veil. Piercing the corporate veil, or lifting the corporate veil, is a legal decision to treat the rights or duties of a corporation as the rights or liabilities of its individual shareholders personally. So the purpose of a corporation is to protect the individual shareholders. If the corporation does something and it sinks to the bottom of the sea, proverbially or metaphorically speaking, it goes bankrupt or something, the liabilities of the corporation generally can't be visited upon the shareholders personally. There is a shield there. That's the purpose of a corporation. But if you're not observing the proper requirements of the corporate form, accounting and some business requirements, some insurance requirements, if you're not using the corporate form properly and observing its legal requirements, then a plaintiff can get through the corporate veil, as they call it here. I'm not sure why it's called a veil, but okay. They can lift the veil and see and get to the person underneath. They say Ted is the alter ego of the Kleins. Ted is a mere shell, instrumentality and conduit through Mr. and Mrs. Klein carry on business in the name of Ted while exercising complete control and dominance over it, to such an extent that any individuality or separateness between Ted and Mr. and Mrs. Klein does not exist. That's one of the requirements, is that they're separate entities. You can't mix assets and monies and accounts and things. And we'll see if that's true. I don't know that Triller actually knows these things are true. Maybe it says so. Maybe it says, yeah, it does. It says upon information and belief. So they're alleging these things upon information and belief. And what information and belief, they're not really saying yet. And they don't have to. Federal Rule of Civil Procedure 8 here just simply says you need a short, plain statement for the grounds of jurisdiction, a short, plain statement of the claim, and a claim for relief or demand for relief. So that's what they're doing here, is they don't have to meet some evidentiary standard at this time. But they are accusing Ted and the Kleins of being the same entity, and therefore the Kleins are personally responsible, is the allegation. Ted was conceived, intended, and used by the Kleins as a device to avoid liability. Well, that's not illegal. That's what a corporation is for. Ted is inadequately capitalized, that compared with the business and the risk of loss, their capitalization was illusory and trifling. And that's going to come into it. I don't know all of the laws behind this off the top of my head, but the arguments are going to be whether they were properly capitalized for their expected risk, and they didn't expect that Triller Fight Club would try to get millions of dollars, $50 million from them or more, from a live stream with commentary of the Jake Paul Ben Askren fight. So if they didn't expect that risk and weren't capitalized or insured for that risk, that doesn't necessarily mean that you pierce the corporate veil. But that's the argument. In addition, many assets of Ted were transferred without adequate consideration to Mr. and Mrs. Klein. Mr. and Mrs. Klein diverted assets from Ted to and among themselves to suit their own convenience in carrying out business matters. Ted is controlled, dominated, operated by the Kleins, and each of them as their alter ego, in that the activities of the business were carried on without annual meetings, without record keeping of minutes or proceedings, or maintaining written resolutions. So this is typical of the corporate form, is to have record keeping. I'm not sure how much record keeping is necessary in order to maintain the corporate veil, in order to maintain that separation, but this is the argument you would make if you are trying to pierce the corporate veil and get at the Ethans personally. So finally they say adherence to the fiction of the separate existence would permit an abuse of corporate privilege, sanction fraud, promote injustice, and otherwise aid in the commission of unlawful conduct. This is true, according to plaintiff, as plaintiff is informed and believes, once again disclaiming having actual knowledge of it yet, defendants were commingling assets in a manner that allowed defendants to utilize and freely transfer those assets among themselves. I don't know that they have any evidence of commingling yet, but that would be the accusation you'd make if you wanted to pierce the corporate veil. Commingling of assets is when you put assets from two separate entities into the same account. This comes up with lawyers. Lawyers are not allowed to keep their personal funds in their trust account, because that trust account is supposed to be for client funds. And especially if you use the trust account for personal funds or personal transactions, you can be disbarred, and very quickly. It is one of the worst offenses that a lawyer can commit, is the breach of trust and the commingling of personal assets in the client trust account. So like a client trust account, if the Kleins commingled assets in the corporate account, yeah, that would allow someone like Triller to pierce the corporate veil. or could allow. I can't say I know exactly what the law in California is about that. It will likely be applied as the law of California because corporate entities and corporate fictions and corporate maintenance and all that are state law, not federal law claims. But because there is a federal claim here for copyright infringement, then you get what's called supplemental jurisdiction over state law claims. Supplemental jurisdiction means that the federal courts can hear state law claims as long as there is a primary claim under a federal law. So there is something in here that we missed. There is an allegation that defendants uploaded all or a substantial portion of the broadcast to an unlisted video and then used that video in the Jake Paul Fight Was a Disaster podcast. Now, I don't know anything about whether H3 or Ethan uploaded the Jake Paul fight to YouTube, so I'm not sure how founded that argument is. But the allegation does persist through this amended complaint. Upon information and belief, defendant Mr. Klein created and uploaded the unlisted video, and then created and uploaded the H3 podcast 244. And they repeat this claim again in the copyright infringement count. Defendants obtained the broadcast through internet websites, cable or satellite pay-per-view purchase intended for private, non-commercial viewing, and subsequently illegally retransmitted the broadcast by illegally copying and uploading the broadcast to torrent and streaming websites. I don't see Ethan doing that, but that's the allegation. Weirdly, this allegation says that the original source seems to have been obtained legally and then was used to create the H3 podcast number 244, which if that turns out to be a fair use, then I don't see a successful copyright infringement claim here with this allegation that the unlisted material was illegally obtained. But that's the allegation. So the plaintiff is going to go through the normal counts. I don't think there's anything new here, and ask for $60,000, $50 million, $50 million, $50 million. I don't think they're going to get multiples of $50 million, but if they won everything, it would be, I expect, slightly over $50 million in damages. If they won everything they claim, I don't think they're going to win everything that they claim. I don't think they're going to win anything at all, but I need to do a detailed analysis of what exactly Ethan did. And I haven't done that yet, because I'm waiting to see what the Kleins have to say. I was actually also waiting for more detail on these claims, because the initial claim just seemed to be for that number 244 podcast, and I thought that maybe there was more to that claim, and it appears that there's not. It appears that it's just a claim for this. Ethan said 45 seconds of the fight that he covered. So I'll do a more detailed analysis of fair use based on just that video alone. And then the docket here shows that the Kleins and TED Entertainment have been served. 21-day summons issued, and then waiver of service was returned. A waiver of service is a really interesting piece of law. If the defendant signs a waiver of service, it buys them extra time. Normally, service and then answer or response has 21 days. As you can see here, I'll zoom in a little bit. But when you sign a waiver of service on 5/25, you get 60 days. So 7/26 is when the answer is due. So we won't necessarily, they could file anytime they want, but the Kleins and TED Entertainment won't file any answer or response. It's not due until July 26th. So that's the H3 update number 4. Update 5, I think, is where I'll do a fair use analysis myself and try to make a prediction as to how strong the case is. Ethan and Hila did a podcast recently that we covered on update number 3, where Ethan did say that he really wants to resolve this out of court. Of course, if he can't resolve it out of court, because either Triller's asking for millions of dollars or something, and Ethan thinks that the offense wasn't worth millions of dollars, or on principle, Ethan doesn't believe he did anything wrong, or whatever the considerations there are. Sometimes it's just a nuisance amount to make a case go away, so you don't have to go to court and litigate and spend hundreds of thousands of dollars in 2 or 3 years of your life, like the Matt Haas case did. So whatever reason they might settle, if they settle, great, then the case will be over there. If they don't settle, then they'll have to respond by July 26th. The response can include asking for more time, can include a motion to dismiss the claims if the defendant thinks that they have grounds to do so. It can involve a motion for judgment on the pleadings, which I don't think you're going to see here, but a judgment on the pleadings would mean that the plaintiff's claims, the pleadings are so slight that the judge can actually use the plaintiff's complaint to enter judgment. It would be rare to see that, but that could happen. And the answer, they could actually answer the claims and say yes or no, these claims are true or false, or we don't have enough information about them. So stay tuned. We'll have more updates for you on the H3 podcast case, which is now no longer the H3 podcast case, but is now the TED Entertainment case, Triller Fight Club v. TED Entertainment. I think it will still maintain its original title. I'm not sure how that works on the court's docket. If it'll always come up as H3 podcast, and then you'll see the parties were substituted. I don't know. I'll take a look at that too. Let me know what you think in the comments below. And that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Floatplane and on twitch.tv/lawfulmasses, live on Sunday mornings at 10 a.m. Eastern Time. This is a community-supported channel, which means I need your money. It takes time and effort to make these videos, and in order to make room in my life, I need to also have support. So I really appreciate your support on patreon.com/ljfrench or sponsors.com/law. You can support the channel through YouTube memberships, or you can support the channel through Floatplane subscriptions. Thank you very much in the month of May to the following $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn, Abel, Torpedan, RDHDragon, Earthbound Star, and ShadowTycho. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. You're all on the LED tablet behind me. I love you all. Thank you for joining me. I'm Leonard French. I'll see you in the videos that drop and the comments below. Bye. Who needs lawnmowers?
I don't know. Can we just get some geese? Honk, 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 honk. Are you filming? So I just honked on your video.
Okay, so no more H3 updates. Yeah, now they're going to be TED Entertainment update.